The Supreme Court chamber was never designed for drama. Its marble columns and hushed acoustics were meant to project an air of solemnity, a place where the law reigned above all else and personalities faded into the background. But on this day, the room was electric with anticipation. The justices sat in their high-backed chairs, black robes draped over their shoulders as a rare joint hearing with members of Congress unfolded. The topic was voting rights and the future of federal oversight, a subject that had already divided the nation and now threatened to divide the court itself. At the center of the storm was Representative Jasmine Crockett, a first-term congresswoman from Texas whose reputation for fearless advocacy had preceded her. She was not a typical witness. Crockett had built her career as a civil rights attorney, fighting for the disenfranchised and holding power to account. She was known for her meticulous preparation, her ability to cut through legal jargon, and her refusal to be intimidated by titles or tradition. Today, she was here to testify about the real-world impact of the court's recent decisions on voting rights. Justice Samuel Alito, never one to shy away from a pointed question, was ready. He had made his skepticism about federal intervention in state elections clear in previous opinions, and he seemed determined to challenge Crockett's arguments before she could even finish her opening statement. As she began to outline the consequences of the court's ruling in Shelby County v. Holder, Alito leaned forward, his voice sharp. Representative Crockett, with all due respect, isn't it true that the states are best positioned to determine their own election laws? Why should this court or Congress second-guess the choices of state legislatures? The question was a familiar one, but the tone was unmistakable, dismissive, almost patronizing. The gallery, packed with journalists, legal scholars, and activists, held its breath. Crockett paused, her eyes meeting Alito's, and then she answered, not with deference, but with clarity. Justice Alito, I appreciate the question. But the history of this country is filled with examples of states using their power to exclude, not include. The 15th Amendment was written because states abused their authority. The Voting Rights Act was passed because states refused to protect the rights of all citizens. When states act to disenfranchise, it is not just the right, it is the duty of Congress and the courts to intervene. Alito tried to interrupt, but Crockett continued, her voice steady. We are not here because states have done too much to protect voting rights. We are here because, time and again, they have done too little. The data is clear. Since the court's decision in Shelby County, we have seen a wave of new restrictions, polling places closed, early voting cut, ID requirements tightened. And the communities most affected are the same ones the Voting Rights Act was designed to protect. The room was silent, the tension palpable. Alito, perhaps surprised by her refusal to yield, pressed on. But isn't it also true that federal oversight can become a political tool? That it risks imposing a one-size-fits-all solution on states with very different needs? Crockett nodded, acknowledging the concern. That's a fair question, Justice. But the answer isn't to do nothing. The answer is to set minimum standards that protect fundamental rights while allowing states to innovate above that floor. The Voting Rights Act did exactly that for decades. It didn't prevent states from running their own elections. It prevented them from running roughshod over voters' rights. Chief Justice Roberts, sensing the gravity of the moment, allowed the exchange to continue. Alito, undeterred, tried a new angle. You speak of data, but isn't it true that some of these so-called restrictions are supported by a majority of voters in those states? Shouldn't local preferences matter? Crockett's response was immediate. Local preferences matter, but constitutional rights matter more. If a majority in a state supports a law that has the effect of disenfranchising a minority, it is the job of the courts to step in. That's not federal overreach. That's the foundation of equal protection. The justices exchanged glances. Justice Sotomayor leaned forward, clearly engaged. Justice Kavanaugh scribbled notes. The audience, sensing that something unusual was happening, sat on the edge of their seats. Crockett pressed her advantage. Let's be clear about what's at stake. The right to vote is not just another policy preference. It is the cornerstone of our democracy. When that right is threatened, it is not enough to say, let the states handle it. The Constitution demands more. Alito, his tone sharpening, tried one last time to regain control. But Representative, isn't it dangerous to suggest that the federal government should have the final say in every election dispute? Where does it end? Crockett's answer was measured, but unyielding. It ends where the Constitution says it ends. The 15th Amendment gives Congress the power to enforce voting rights. The Supreme Court's job is to uphold that authority, not undermine it. When states use their power to disenfranchise, it is not just permissible, it is necessary for Congress and the courts to act. The room was silent again, but this time it was a silence of reckoning. Crockett had not only refused to be shut down, she had turned the tables, exposing the limits of Alito's argument and reminding the court of its own constitutional obligations. As the hearing continued, it was clear that something had shifted. The justices, the audience, even Justice Alito himself, were no longer in control of the narrative. Jasmine Crockett was. The hearing pressed on, but the energy in the chamber had changed. Crockett's words echoed in the marble, and even the most seasoned legal minds in the room sensed that the usual script had been torn up. Reporters in the gallery exchanged glances, already drafting headlines in their minds. Justice Alito, for all his composure, looked unsettled. He was used to controlling the tempo, but Crockett had seized it with a mix of legal acumen and lived experience that was impossible to ignore. Justice Kagan, always the pragmatist, leaned in. Representative Crockett, you've made a compelling case about the real-world impact of our decisions. But what would you say to those who argue that federal oversight risks undermining state sovereignty? Crockett met her gaze. Justice Kagan, I respect the principle of federalism, but sovereignty can't be a shield for discrimination. The 14th and 15th Amendments were written precisely because states abused their power. When states use their authority to block citizens from the ballot box, it's not just Congress's right, it's Congress's responsibility to act. The Supreme Court should be a backstop for democracy, not a bystander. Justice Gorsuch, skeptical, pressed further. But isn't there a risk that federal standards become a one-size-fits-all solution, ignoring local context? Crockett nodded. That's a fair concern, but the answer isn't to do nothing. The answer is to set minimum standards that protect fundamental rights while allowing states to innovate above that floor. The Voting Rights Act did exactly that for decades. It didn't prevent states from running their own elections, it prevented them from running roughshod over voters' rights. Alito, trying to regain control, interjected, Representative Crockett, you've referenced the Voting Rights Act repeatedly, but the court's role is to interpret the law, not to make it. Isn't it Congress's job to update the act if it's out of date? Crockett's reply was swift. Absolutely, Justice Alito, but the court's job is to interpret the law in a way that honors its purpose. When the court gutted Section 5 in Shelby County, it didn't just interpret the law, it rewrote the rules. Congress can and should act, but the court must recognize the real-world consequences of its decisions. Otherwise, we're left with rights on paper and barriers at the polls. A hush fell over the room. Crockett's critique was bold, but it was grounded in precedent and principle. She wasn't just challenging the court, she was challenging the very idea that legal reasoning could be separated from lived reality. Justice Sotomayor, visibly moved, asked Representative Crockett, what would you say to the young people watching this hearing who feel their voices don't matter? Crockett's voice softened, but her conviction deepened. I'd tell them that democracy is a fight, not a gift. Every right we have was won by people who refused to be silent. The court's decisions matter, but so do the voices of those who demand justice. Don't let anyone, no matter how powerful, convince you that your vote, your story, or your future doesn't count. The audience, usually reserved in such settings, responded with a quiet but unmistakable wave of approval. Even some of the justices seemed to take note. Alito, sensing the momentum slipping, tried to pivot. Let's discuss the practicalities. You've argued for restoring preclearance requirements, but critics say that's an outdated remedy for a different era. How do you respond? Crockett didn't hesitate. The tactics may have changed, but the goal is the same: to suppress the vote. Preclearance worked because it forced transparency and accountability. If states aren't trying to discriminate, they have nothing to fear from oversight. The only people who oppose sunlight are those with something to hide. Justice Barrett, measured and precise, asked, "But how do you ensure that federal oversight doesn't become politicized?" Crockett answered, "By making the process transparent, data-driven, and subject to judicial review. Oversight isn't about partisanship, it's about protecting the foundation of our democracy. If we can't agree that every eligible citizen should be able to vote, then we've lost sight of what this country is supposed to stand for." Alito, perhaps realizing that Crockett was not going to be boxed in, tried one last time to assert his authority. "Representative Crockett, we appreciate your passion, but the court must remain above the political fray." Crockett's response was measured, but unyielding. "Justice Alito, justice isn't neutral when neutrality means ignoring injustice. The court's legitimacy depends on its willingness to confront uncomfortable truths. If the law is used to silence the vulnerable, then the law itself becomes complicit." The room was silent again, but this time it was a silence of reckoning. Crockett had not only exposed the limits of the court's traditional approach, she had forced the justices and the country to confront the gap between legal theory and lived experience. As the hearing drew to a close, Chief Justice Roberts offered a final, carefully worded statement about the importance of civility and respect for institutions. But the words felt hollow. The real story was already being written outside the chamber, in headlines, tweets, and conversations across the country. Crockett gathered her papers, thanked a committee staff, and walked out of the Supreme Court with her head held high. She had come to speak truth to power, and she had done exactly that. The marble columns, the velvet drapes, the black robes, they were still there. But for one afternoon, the power in the room had shifted. As she stepped onto the courthouse steps, reporters swarmed her, microphones thrust forward. "Representative Crockett, do you think you changed any minds today?" one asked. Crockett smiled. "I didn't come here to change minds. I came here to tell the truth. Sometimes that's enough to change everything." The aftermath of Jasmine Crockett's appearance before the Supreme Court was immediate and far-reaching. News outlets replayed the exchange between her and Justice Alito on a loop, each network offering its own spin, but all agreeing on one thing: Crockett had not only held her ground, she had shifted the terms of the debate. Editorials praised her composure and command of the law, while social media exploded with hashtags like #Crockett shocks the court and #Truth in the chamber. Clips of her calmly dismantling Alito's arguments were shared by law students, civil rights activists, and even a few unexpected voices from across the aisle. In the days that followed, Crockett's office was flooded with messages, some from young lawyers and students inspired by her example, others from community leaders who saw in her a champion for those too often left out of the conversation. She responded to as many as she could, always returning to the same message: your story matters. Your work matters. Don't let anyone tell you otherwise. Meanwhile, the policy debate she had come to champion gained new momentum. Lawmakers who had been on the fence about federal voting rights protections now asked for briefings with her staff. A bipartisan group of senators requested a meeting to discuss the restoration of preclearance and how its principles could be adapted for the modern era. Even some of Alito's colleagues, privately if not publicly, admitted that Crockett's arguments had forced them to reconsider their assumptions about both the law and the people who practice it. Crockett's influence grew, but she remained grounded. She continued to visit the communities she represented, holding town halls and listening sessions, making sure that the voices she brought to Washington were never drowned out by the noise of politics. At one such event, a high school student asked her how she stayed so calm under pressure. Crockett smiled and replied, "When you know who you are and why you're here, it's a lot harder for someone else to shake you." The story of the hearing became a case study in law schools and public policy programs. Professors played the video in classrooms, asking students to analyze not just the legal arguments but the rhetorical strategies and the importance of representation. One professor at Howard University called it a masterclass in turning a personal attack into a public lesson. Another at Stanford noted that Crockett's performance was a reminder that The law is not just about where you studied, but about what you do with what you've learned. Justice Alito, for his part, tried to move on. He gave interviews insisting that his questions were about constitutional principle, not personal attacks. But the narrative had already shifted. In the public imagination, he was the justice who tried to shut down a witness and ended up exposing his own limitations. Even some of his supporters quietly acknowledged that he had underestimated his opponent. The broader impact was felt in the halls of Congress. Lawmakers from both parties began to reconsider how they approached hearings and debates. The old playbook, rattle your opponent, question their credentials, dominate the soundbite, suddenly seemed less effective. Instead, there was a renewed appreciation for preparation, substance, and the ability to connect policy to real people's lives. Crockett's colleagues took notice. Senior members who had once dismissed her as a newcomer now sought her advice on legal strategy and public messaging. She was invited to join bipartisan working groups on voting rights and civil rights. Her expertise and perspective now seen as assets rather than liabilities. The chair of the Judiciary Committee, in a rare moment of candor, told a reporter, "We need more voices like hers, people who know the law, but also know what it means to live it." As the legislative session wore on, Crockett continued to push for reforms, always returning to the principles that had guided her from the start: justice, accountability, and the belief that the law should serve everyone, not just the privileged few. She worked late nights with her staff, refining proposals, building coalitions, and never losing sight of the people whose stories had shaped her own. The legacy of that hearing was more than a viral moment. It was a turning point, a reminder that expertise comes in many forms, and that the most powerful arguments are often the ones rooted in lived experience. Crockett's law degree, once questioned by skeptics, became a symbol of resilience and determination. Her story inspired a new generation of advocates, lawyers, and lawmakers to believe that they, too, could make a difference no matter where they started. In the end, Jasmine Crockett didn't just shock the court, she elevated the conversation, set a new standard for public service, and proved that the measure of a leader is not where they went to school, but what they do when the spotlight is brightest. As she left the Capitol one evening, the city lights reflecting off the marble, she paused for a moment, looking back at the dome. She knew the work was far from over. But she also knew that for one unforgettable day, she had shown the country, and herself, what was possible when you refused to be defined by someone else's expectations.